Welcome back, everyone. Today's case looks simple on paper. A routine non-payment of rent hearing, but within seconds, the numbers start raising eyebrows. We've got a landlord's representative presenting a financial breakdown that sounds unusual, a tenant who believes the rent figures don't quite line up with what she's been told, and a judge who has to cut through the confusion in real time. Eviction court often moves incredibly fast, and that speed itself becomes part of the drama. There's very little room for storytelling. Very little patience for explanations, and yet, for the person facing eviction, everything feels life-altering. Pay close attention to how quickly critical decisions are made here. Notice how financial terminology, lease language, and procedural rules start to dominate the conversation almost immediately. Also, listen carefully for the tension between what feels fair and what is legally sufficient. Those two things don't always overlap in eviction cases, and that gap is where many tenants get blindsided. As the figures are introduced and the judge starts clarifying the rent amounts, ask yourself, are these just clerical inconsistencies, or is something more complicated happening beneath the surface? And most importantly, imagine being in the tenant's position. You're trying to explain job loss, a roommate moving out, utility problems, while the court is primarily focused on balances, notices, and statutory compliance. This hearing becomes a perfect example of how eviction proceedings are often less about personal circumstances and more about whether specific legal boxes have been checked.
Ms. Weiss, tell me why this case is being heard.
Non-payment of rent, Your Honor.
All right, what's the monthly rent?
Monthly rent is $18.81 on the lease, but they were only charging $18.56, so I went with that number.
Okay.
They owe back rent for August $287.57, September $18.56, in October I prorated at $957.93.
Let's pause right here because this is where viewers often get confused. And honestly, many defendants do too. We've just heard multiple rent figures tossed around, numbers that sound similar but carry very different legal implications. In eviction court, precision matters. Even small discrepancies can change how arrears are calculated or what the court ultimately awards. What's fascinating is how calmly the judge navigates this. Instead of getting stuck on the higher figure, the court immediately gravitates toward the lower monthly rent. That's not random. Courts typically prefer the most defensible, clearly documented amount, rather than risking an inflated or disputed number. From a legal standpoint, that's risk management. From the tenant's perspective, though, it may feel like the numbers are shifting midstream. And here's something worth thinking about. How many renters truly understand what portion of their monthly payment is considered recoverable rent versus fees that may not hold up in court? Trash fees, amenity fees, convenience charges. Those details can quietly become very important during hearings like this. So ask yourself, if you were the tenant, would you recognize which charges legally count and which might not?
For a total of $3101.50. We did do a 3-day, or they did a 3-day notice to vacate. The lease has a 24-hour notice to vacate on 09/09 of 2025, posted inside door.
All right, and I think I already know the answer, but any subsidy?
No, not that I saw in there.
All right. Good morning, Ms. Faraci. Ms. Weiss doesn't work directly for the landlord, so you've probably never seen her or heard her name. She works for a group called Nationwide. She's just here to handle the case for them. But what she said, this case is about a financial situation, so no allegations of bad acts or harming anything in the unit. She said that the monthly rent is $18.56. Is that correct?
So the rent that I have seen on my ledgers is $18.81, with fees as well. I'll have to check again, but it has been $18.81.
I appreciate that. In fact, Miss Weiss said
I know that increases the amount.
But when she looked at what they're actually charging you, they're asking $18.56, and I'm happy to go with the smaller number, right?
Yeah, absolutely. I just, for accuracy's sake.
I appreciate that. I do. And sometimes what it might be is that there might be like a convenience trash fee or a pool fee, and in court, the landlord is moving that out because it's not technically something they can recover for. So there may be some convenience fees or something in there. Either way,
maybe there is something. Yeah.
Okay.
I'm
well,
curious,
here's another question then. Is it correct that August had a balance remaining of $287?
200, yes, that is accurate.
All right, and then how about for September and October? Rents remained unpaid?
Yes, ma'am. So for basically this whole situation, you know, it's just a series of events of me losing my largest client, and then my roommate suddenly moving out. And, maintenance management knows all about that. I've communicated. And I picked up a new job. It's just also my electricity went out. So I have to get that reconnected for it even to be a livable space. And I've just been working hard, odd jobs, selling things in the apartment since then. But, I've also applied for financial assistance with
Okay.
multiple programs. And I actually attached to this case is my answer, as well as like the evidence supporting my answer in the fact that they did not actually give me legal notice to vacate. From what I'm so sorry, I forgot the woman's name who's
His wife.
presenting.
His wife.
Thank you. But yes, they did post a paper on the inside of my door, taped it. But I wasn't notified of that paper until I received a call. So
Yeah,
from
legally,
oh,
what they did is all that Texas law requires. And in fact,
okay.
Ms. Faraci, this is beginning January 1st. Or the law says as long as they have proof that you knew it all, that's all that's required.
So that's part of okay. So then I'd love to okay, so
So the letter inside the
they
door, totally sufficient under the law of Texas. And it's going to be even easier beginning next year for them to notify you. They can text message you. You have 3 days to move or leave. That's going to be considered notice.
so okay, so that's fascinating, and I'd love to look into that more. My legal aid told me that that wasn't a proper notice, but
I'm
I
looking
didn't
at the
actually
notice to vacate.
receive that notice until
If this notice to vacate was posted on the inside of the door, that 100% counts.
I did not. Oh, and they could say it was. I did not see it until after I received a phone call a couple of weeks later from management saying they were filing the eviction, and like I had 2 hours to pay immediately, or not pay immediately, but to agree to pay and hand in my keys. And they said, I mean, there's a whole lot of things, but ultimately I thought at that moment that's when the eviction was filed, and that was 9/17. So I was kind of
They filed on
just
the 28th. They filed 11 days later.
exactly. So basically a few days after that, or maybe a week after that, I have a official timeline here. I I was illegally locked out of my apartment. That's kind of what spurred the, I think, official eviction notice was when I did come home to my apartment being locked, the lock being changed. I'd just gotten off of the night, and yeah, the next day I
Rossi,
had to get a hotel. I was like,
Mr. Rossi, when
greatly
you came home,
distressed.
you
Yes.
said that they changed the locks. Did they give you a piece of
Yes.
paper that said, here's the phone number to reach us 24 hours a day to get in? Because the landlord,
So they did not at that point. So when they changed the locks, it was after hours of the apartment. It was after a Friday. I received no notice, any sort of information in regards to my lock being changed. And so I did leave, stay in a hotel. I emailed management the next day, stating that I'd seen that I was locked out and that wasn't in accordance with legal proceedings. And that day, for the first time, management emailed me back and said that they had not changed the locks. That, that's when he emailed me that if you have, he said, rest assured, last time I checked, your door was unlocked. And yeah, try your keys now if you're having any problem. I really do have it right here.
Okay. Ms. Rosie, here's the thing. And so the landlord, legally, they can change the locks on you. They just have to give you access to it within 24 hours. They have to give you a number where you can call them, they can let you back in. But they absolutely can change the locks on you if you're behind on the rent. It's not fun for either party to do that, but it's not illegal in and of itself. They have to give you access to it again, and it sounds like the landlord did.
This segment is packed with legal nuance. The tenant is describing what feels like an illegal lockout, while the judge is analyzing it strictly through statutory requirements. That distinction is critical. In many jurisdictions, changing locks is not automatically unlawful. It becomes unlawful if specific procedural safeguards aren't followed. Notice how the judge frames this. The legality hinges not on the tenant's emotional experience, but on whether access mechanisms were provided as required by law. That can be incredibly jarring for defendants. Feeling blindsided or distressed doesn't necessarily invalidate the landlord's actions if the technical rules were satisfied. There's also a subtle credibility dynamic unfolding. The tenant recounts confusion, emails, timelines, uncertainty about when events occurred. Courts, however, heavily prioritize documentation and verifiable compliance. This often leads to outcomes that feel cold or mechanical to viewers, even though they're legally consistent. Here's a tough but important question for the audience. Should landlord-tenant law weigh lived experience more heavily, or is strict procedural clarity the only workable standard in high-volume courts?
But I'm going to give you some more information today because this is much more important for you. Mr. Rossi?
Yes, ma'am.
So today, for non-payment, the case is going to be for the plaintiff. The judgment would be for them. You have the right to appeal. And I'll give you some specific information about what you can do in the next 5 days that may be of use to you, okay? It's just information. Today, the judgment is for the plaintiff, and the amount of money is no, that's wrong. Sorry, y'all. $3,101. Right? That's it, 3101. Either party can appeal, and I'm going to put the appeal bond at 1856, which is what Ms. Weiss told me the rent is going to be used at, right? And I understand that the lease might have said 1881, but for our purposes today, 1856.
Okay.
Ms. Rossi, you have 5 days beginning tomorrow. In the next 5 days, if you want to appeal, you can contact our court. We're going to email you information today to appeal. If you want to appeal, but you don't have 1856 for the bond, you may still be able to qualify for an affidavit of inability and appeal for free. All right. However, this is an important caveat. Even if you can appeal for free, if you want to keep living in the apartment until the next judge hears your case, you have to pay 1856 to the court. And we will give you an exact date and time that when you got to bring us that money. Okay.
Well, okay. So this is a situation. Oh, yes.
If you don't have that money, you mentioned that you had contacted legal aid, contact them again and tell them I was evicted this morning. Very commonly, I have people tell me that they were on a wait list until they got evicted and then legal aid could assist them faster. Now you are in, it is official. You've been evicted. You have 5 days. If you don't do anything on day 6, the landlord gets a writ of possession and can make you move out with your stuff. That's the soonest they can legally do that. They have the ability to wait up to 60 days to do it. Legally, you have at least 5 more. All right. And what questions can I answer?
Well, okay, so I kind of have a concern with even going back because my management, my property maintenance was waiting for me outside the apartment complex and followed me in and kind of intimidated me, put me in this whole situation where I'm talking to you in my car and having technical difficulties and and so like now I feel more intimidated and like generally I don't want to be there now anyway.
Okay,
but
you don't have to do anything.
Yeah,
you
so
have 5 days before it becomes
I
final.
have 5 days to file an appeal. Yeah.
5 days to appeal.
Yes, ma'am.
You can talk to the landlord as well in that 5 days. I'm just saying that if nothing changes after 5 days, it's official. And if you haven't left, that's the soonest they can legally make you leave. All right.
Yes, ma'am.
All right.
Yes,
Good luck,
absolutely.
ma'am. Thank you for coming. I'm glad we were able to give you that information.
What we've just witnessed is a textbook example of how eviction proceedings operate: fast, procedural, and heavily driven by statutory compliance rather than personal hardship. The judge's ruling centers on non-payment, confirmed balances, and legally sufficient notice, not on the tenant's job loss, roommate departure, or utility difficulties. That distinction, while legally standard, often feels emotionally stark. We also saw how rent calculations, notice rules, and appeal procedures can shape the entire outcome of a case within minutes. The appeal bond requirement, in particular, becomes a pivotal barrier. Even when a tenant may qualify to appeal without paying the bond itself, maintaining possession during that appeal introduces another financial hurdle. These layered rules illustrate why eviction law can be so difficult to navigate without legal guidance. Cases like this highlight a broader reality. Housing disputes are rarely just about money. They involve timing, documentation, communication, and an intricate legal framework that many participants only encounter under extreme stress. If you found this case as eye-opening as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.